Welcome to the 2020 Virtual Spring Meeting, brought to you as a special edition of Our Curious Amalgam, the American Bar Association Antitrust Law Section's podcast. Virtual Springs Eternal, Friday, April 17th through Friday, May 1st, as we bring to you some of the top programs from the now canceled in-person spring meeting, as well as new hot off the press programs discussing the most compelling issues of the day. Be well and enjoy the show.
Hi, and welcome to the Virtual Spring Meeting. My name is John Roberti, and today we have another great panel. Sequences and Sparks, Life Sciences Innovation Mergers. The panel is presented by the Healthcare and Pharmaceuticals Committee. And with me to provide some context today is Lauren Rackow. Lauren is counsel at Cahill, Gordon & Reindel, LLP. She is also co-chair of the Healthcare and Pharmaceuticals Committee. Hi, Lauren.
Hi, John. How are you? And thank you for having me.
Wonderful. Well, thanks for being on. So, Lauren, let's get right to it. What is today's panel about?
So today's panel is about innovation mergers, particularly in the life science and the pharmaceutical arena. It really focuses both on how to evaluate these mergers and what remedies that you might need in order to resolve any issues that arise, from a competitive perspective with the mergers.
And Lauren, why is this important?
I think this is a really important area, and it's really for two reasons. The first one is because this is really a unique area. I mean, these types of mergers that impact, what might happen in the future, and especially when we're in the healthcare arena, really have the potential to save human lives or to really affect and change disease and how diseases are possibly treated. So that's the first reason. It's just a very important area. And the second reason is that at the same time, the impact and how to analyze these mergers is more difficult because while all mergers look forward to the future, the impact here is even more of an unknown, and it is even more difficult to predict.
What do you think we're going to get out of today's panel?
Well, I think that we will learn how these types of mergers are evaluated. What are the key factors that the agencies use, both here and across the pond? What are the key factors that we use to look at how to evaluate what the product market is here and how you evaluate any anti-competitive effects? And I think we will also learn, what remedies might be utilized in evaluating these mergers as well, if the agencies want to allow them to go forward, but do see some issues that need to be resolved.
Great. Lauren, will you stick around with me and we'll listen to the program and then come back and we can talk about your takeaways? Is that okay?
That sounds great. Looking forward to it.
All right. With that, let's send it over to the panel's moderator, Bill Batchelor. Bill, take it away.
Thanks, John. Hello, everyone. Welcome to Sequences and Sparks, Life Sciences Innovation Mergers, our virtual spring meeting podcast. I'm your moderator today, Bill Batchelor. We confidently and indeed competitively predict this is the most interesting merger podcast of the VSM, so keep your ears firmly in the upright and attentive position. Innovation theories just seem to get more topical every day, and our day of recording is no exception. Hot off the presses, we have a clash of findings specifically on innovation. In Sabre Fairlogics, the Delaware court just yesterday issued an opinion saying that the Sabre Fairlogics transaction would increase innovation, paragraph 246 and pages 90 to 91. But just an hour ago, we learned that the CMA in the UK disagrees with that assessment. Innovation will be harmed, it tells us in its press release issued today. To tell us who is right or wrong on these innovation theories, we have three exceptionally eminent practitioners join us. Deborah Feinstein, head of Arnold Reporter's Global Antitrust Group, formerly director of the Bureau of Competition at the FTC. James Weiss, Deputy Assistant Director, Mergers One at the FTC, and Bob MAJURE, Vice President of Cornerstone and formerly Director of Economics at the DOJ. Stepping gingerly between these eminent practitioners, I'll be your moderator, Bill Batchelor from Skadden Arps. I should also say that opinions expressed today are personal and not those of our organisations or anyone we represent. Setting the scene very briefly for our eminent panellists, let me just set out two recent case studies from my home jurisdiction. And indeed, these are the two cases that lend their names to this podcast, Sequences and Sparks. First off, Sparks. In Roche Spark, we have the CMA examining Roche and Sparks haemophilia treatments. Under traditional analysis, this wasn't an overlap case. Factor VIII replacement tends to be a narrowly defined market. And Roche's Hemlibra and Sparks gene therapy were very much different products, mode of action, patient group, price, efficacy, all those traditional market definition tools. Here, to look at the innovation issues, we see the CMA rather moving the goalposts. It says instead there could be a market for all novel treatments at 134, and this is on the basis of internal documents monitoring rival company pipelines, no matter how different or novel those treatments might be. We see certainly a novel approach to assessing potential competition effects as well. Roche's treatment had less than 5% share, the CMA finds, but could be predicted to rise as high as 60% in 5 years at 181 to 185. Hence the potential for concern, albeit one involving much crystal ball gazing. In the end, however, new gene therapies from other suppliers would continue to constrain Roche, the CMA found, and so the deal was cleared. Secondly, Sequences. This is Illumina PacBio, which the CMA provisionally found competition concerns. Here we have Illumina's short-read DNA sequencing machines, PacBio's long-read sequencers. The CMA agrees these technologies have different applications, 734 to 38, and were likely to do so for the foreseeable future. But again, we have a degree of goalpost moving in order to get at the innovation issues. So at 7.2 and 744, we find the CMA jettisoning traditional market tools like the SNP test to find that it can predict short and long read will compete at some point in future at 8298. So unlike Roche Spark, it was provisionally determined that other potential entrants would not replace the innovation lost by this deal. The deal was then abandoned. So with those two case studies setting the scene, let's turn to our panel. Perhaps, James, going to you first. We've seen a number of life science merger innovation reviews in the past year. How does the FTC tend to approach these types of cases?
Hi, thanks, Bill. First, I'll start with the standard proviso for these sorts of panels. The views I'm to express today are, of course, my own, and do not necessarily represent the views of any of the commission or of any particular commissioner or bureau official at the FTC. So, with that said, maybe I'll start with really the widest lens possible in terms of when a matter comes before the FTC and we're evaluating potential innovation theories. As will surprise no one, we typically are going to start by looking to the horizontal merger guidelines for guidance about how to think about the analysis of potential unilateral effects that can arise or could arise or may be likely to arise due to diminished innovation competition that consumers might face as a result of a proposed merger or in some cases of a consummated merger. The guidelines at a high level really focus on two kind of broad categories of innovation competition that the agencies here in the United States began the analysis with when they're kind of framing, looking at potential innovation issues. In really all these innovation cases, there's kind of a wide spectrum of potential issues that you could analyze. The guidelines first talk about what I think of as sort of the most straightforward innovation type of theory, where you're looking at a merger where you have potentially evidence that shows that the merged firm will have a reduced incentive to continue with some sort of existing product development or R&D effort. So here what you're talking about, of course, are an identifiable product that each party has. Typically, you can see it in sort of two flavors. You could have an on-market product that one of the firms has, and then the other firm has an identifiable pipeline R&D project that looks like it would compete closely with and be a close substitute for the other party's product. You could also have pipeline to pipeline, of course, where it was sort of a double competition flavor as well, where both of the parties' products are in the pipeline. I'll talk about some examples of recent and notable cases that fall into that bucket in a moment. The guidelines, of course, also talk about kind of at the other end of the spectrum about mergers that may be likely to diminish or reduce or even eliminate innovation competition by combining two of the very small number of firms with the strongest capabilities to innovate into a specific direction. So sort of with those kind of, broad, with that broad framework, there are a range of different types of innovation mergers that can fall under the guidelines analysis that we undertake. Focusing first on the kind of first type of innovation theory that I identified that the guidelines contemplate, where you're talking about a reduction or a likely reduction in innovation competition before regarding an identified product. There are a couple of different flavors of case or matter that exist on that spectrum. I think the most kind of one of the easiest to get your head around is a product to pipeline case or a pipeline to pipeline investigation or overlap as identified. Sort of paradigmatically, I think about pharmaceutical cases as really cleanly falling into that bucket, where you could have a branded pharmaceutical market or perhaps a generic pharmaceutical market, where you have the merging parties, either have a pipeline to pipeline, kind of double actual potential competition overlap, or where one firm has a product on the market. The aforementioned Roche Spark case falls roughly into that bucket, while Roche had Hemlibra on the market, which was a monoclonal antibody product that could be used to treat severe bleeding issues in connection with hemophilia A. Spark, of course, as Bill mentioned, had a gene therapy pipeline product, and the focus of that, at the FTC, nearly 10-month investigation before the investigation was closed, was on identifying exactly how intense the competition was likely to be between these two, quite differentiated ways for treating a very serious underlying disease. Generic pharmaceutical cases would be another example where it's really common to see the pipeline to pipeline overlap that presents an innovation competition issue. Then as you're kind of moving through the spectrum, and if you're looking towards a case that raises issues that are non-product specific, that involve a field or a capability of research. So in this case, you could be thinking about instances where there's a particular disease type that might be rare or otherwise just very difficult to engage in and to provide expertise in. And the merging firms are two of very few companies that participate in that kind of broad field. Cases that involve that, several recent examples. One that comes to mind is DOJ's Bayer-Monsanto matter from 2018, which was, of course, a mega deal. It was a $66 billion deal. There were a range of divestitures to address both horizontal and vertical issues, as well as innovations ones. And in that case, the evidence showed that both Bayer and Monsanto were two of very few companies, DOJ argued, that were, had the capability of doing research and investing in advanced crop sciences applications. And so in that case, in addition to the other divestitures to address the horizontal and vertical issues, you had a divestiture of broad IP and research capabilities, which included, pipeline and R&D projects, as well as complementary assets that would be necessary to restore competition in that kind of broad sense that the DOJ had identified and was concerned about. There's an element of that, as I understand it, as well, in Sabre Fairlogics, where Fairlogics was identified as particularly innovative and as a company that directionally was very, very innovative, and that Sabre was concerned about. I think that sort of leads to yet another kind of flavor or type of innovation merger that Illumina PacBio falls into this category, and that's the acquisition of a nascent competitor. In that case, Illumina, by any standard, was the dominant firm in next generation sequencing. As Bill alluded to, it had a short read next generation sequencing product, and you had, on the other hand, it was seeking to acquire PacBio, which had a differentiated long read product that competed to some degree currently with PacBio's product, but also really importantly in the future, the evidence showed it was poised to compete for more and more NGS applications, and that both the parties and a range of other sources of evidence suggested that competition was poised to heat up and to continue to benefit consumers to a really substantial degree. Another case that falls into that kind of analytical bucket, and I should note that Illumina was notable for a couple of reasons here in the United States, but one of them was that in addition to a Section 7 theory of harm, the Commission in its complaint alleged that Section 2 of the Sherman Act applied, which is by no means a novel application of a theory that that Section 2 can be used as a merger control statute, but the facts under which you're going to see that kind of a challenge are very specific. You're going to need to have essentially a monopolist whose acquisition of the target company that has been identified as a nascent threat, that acquisition itself, under the right facts, can constitute anti-competitive conduct under Section 2. So maybe I'll stop right there for a moment, although there are, of course, many other cases we could allude to, and I'll see if any of my esteemed colleagues have comments of their own.
Thanks, James. No, very helpful. So I thought that was a useful categorization. You have product to pipeline, pipeline to pipeline, and then there are the more esoteric, looking just at capabilities or buying out a disruptor. Debbie, having seen these cases both on the enforcer's side and as a private practitioner, what's your takeaway on these?
I'd start by saying that I agree that it's really important to figure out what it is that you're talking about. What is the possible effect? That'll help you determine what evidence you need to look at and the like. So, one example, and we've talked about the various names, but the paradigmatic one that the FTC looks at in pharmaceutical mergers is where you've got a generic product that's going to come on the market in a period of time. At some point, the FTC started calling those not potential competition cases, but just future competition cases. There wasn't really a lot of doubt as to whether or not the company was going to be there. And the question is, what was the effect going to be? And study after study showed that the more generics you have, up to a point, the lower the prices are. So pretty standard stuff. And a lot of that is just counting up who's going to be in and when they're going to be in. Not to diminish the amount of work that may go into that, but the analytics aren't terribly complicated. Then you have what's really potential competition, which is somebody's trying to get into the market, and what you're worried about is what the state of the market will look like if they do or don't get in. In other words, are you going to diminish the number of competitors that are actually on the market? And that was Stereosynergy was really, I think, a potential competition case, because the debate was over not only what the effect would be if they got on the market, but whether they would actually get on the market. And that's really what the trial was about. In that case was whether or not the company would have been on the market but for the merger. And there were documents suggesting that they had been well on their way, documents suggesting that the reason they shut down the program was because of the FTC's investigation. They had talked to customers about, developing the product. On the flip side, as the court found, there was evidence that there were real questions about whether or not it would be successful. There were real questions about whether or not the customers were going to buy the product. And so it was just a debate about will they or won't they. Then there's a step back, which is really innovation competition, and that comes in a couple of flavors. And this is the one I think that is toughest to tease out what the evidence really is and what predictions you can make. We have pretty good models that say if there are 4 competitors rather than 5 competitors, or 2 competitors rather than 3 competitors, this is how you ought to think about it. These are the economic effects. I think with innovation, it's a lot less clear. I don't think that there's, the same sort of economic consensus that if you combine companies who innovate as opposed to keep them apart, that you're going to get less innovation or more innovation. There's not an easy way to measure market shares of innovators. I don't think dollars spent is a good measure of the effectiveness of somebody's ability to innovate. It might, in fact, show that they're quite inefficient. The more they spend, but the more they don't get. Does that mean they're a better innovator, or is the really good innovator the one who doesn't spend very much money in his or her garage? So basically trying to figure out competition in innovation, I think, is much more difficult. I think there's also a question about thinking about efficiencies and the benefits of collaboration. And the example I always use for that is Genzyme, Novozyme. So the situation there, very unique set of facts, was you had 2 companies who'd been trying to develop a product for something called Pompe disease, something that affects newborns and infants. And people had known of the disease for 50 years. Nobody had been able to find a cure. Now you have these Genzyme, a fairly well-established company, trying to develop something, and then Novozyme. Novozyme was founded by the father of 2 children who had the disease. And over time, he believed that the best way to come up with a product was to put all the best minds in a room and basically figure it out. They had different cell strains, they had different ways of approaching it, and he thought, let's all get together and figure this out. It was an orphan drug, which meant that it was almost certain there would only be one product on the market. One of them would get orphan drug designation, whoever got there first. So this wasn't really a question about what the effects were going to be in a future market. The question was there a diminution of the incentive to race to be the only one to market? I represented Genzyme in that case, and we argued, no, everyone was going to race as fast as they could anyway, because you don't make any money until you're on the market. So there was no reason to slow things down, number one. And number 2, we argued that the CEO had a personal interest in not diminishing innovation. Interesting case. Now, what was particularly unique about that was it turned out it was a non-reportable case. So we actually got to see what happened, and we were able to argue that there were efficiencies. There were things that had been done together that could not have been done together that actually progressed development of the disease. Ultimately, on a split decision, the commission decided to close the investigation. But I always wonder what would have happened in a case like that if it had been a non-reportable transaction. We hadn't been able to show the benefits of the innovation. The point is that figuring out exactly what the theory is, are you talking about a reduction to get to the market? Are you talking about a reduction in competition once you're on the market? Those things and making sure you understand the fundamentals of the theory are really important to being able to figure out what evidence matters and how you want to be thinking about it, because like all things antitrust, the facts really matter.
Thanks, Debbie. And my favorite one on the capabilities type innovation is always Tokyo Electron Applied Materials, which I think, to your point around Genzyme, it's all about the German authority says, well, the two parties here have complementary skill sets and so might bring about a breakthrough innovation in wafer technology more quickly than if they were separate. And although we don't know what would have happened, it said the DOJ was all set to challenge the same deal for the opposite theory, that apart they would have competed in innovation more aggressively. Maybe, Bob, that brings us rather nicely to you. We've seen a number of papers on innovation and merger control in the past couple of years. Some seem to suggest innovation just one price parameter, so more concentration you have, the less innovation you'll get. Others say, well, that's rather too simplistic. Surely innovation is much more complex. It will depend on the type of innovation, incremental versus breakthrough, how close the parties are in terms of competing. Is there a consensus emerging, or is it all too difficult to tell?
Well, picking up on what Debbie was saying about this being an area, these innovation competitions where there's not really a consensus now. I guess the way I would phrase it is, have we gotten closer to a consensus? I think that the reason fundamentally that there's not a consensus among the economic models is that the creative process is something that doesn't lend itself to economic modeling. I mean, we all know what happens if you build a second factory. You have twice as much potential to produce the product, and that makes it easy to build a model around, well, if that additional capacity is in the same firm, how will they internalize the effect of that extra capacity? And if it's in another firm, how will they compete? If you build a second research lab, are they literally going to reinvent what the first lab did? Or are we going to have twice as much possibility of having a truly innovative and creative breakthrough, or something in between? And there really is no clear-cut, obvious answer to that question. And so it has sparked a variety of approaches or modeling scenarios that leads to this lack of consensus, if you will. A few years ago, there was kind of a move to try and at least categorize the variety of theories that more or less led to identifying three considerations that kind of help determine which of the theories seems more relevant. Putting these very generally, I'd say the first one of these is to ask the question, how big is the prize? What is the gain from being a successful innovator? A lot of times this gets described in competition circles as the contestability principle. And the reason is, the intuition is that if you are currently splitting a market 5 ways, say, and you come up with an innovation that lets you win the entire market, you have a lot more to gain than if you were already a monopolist. That intuition, however, depends a lot on the nature of the innovation that is being assumed. If I instead of having some kind of innovation that's going to completely disrupt and transform the industry, if I am assuming that it's really more likely that I'm going to achieve a process innovation, it might actually be more profitable to be able to realize that cost savings or increase in quality over a larger share of the market. So this contestability, or how big is the prize kind of principle, needs to be understood in terms of the facts of the case and what in this industry is the real nature of that kind of innovation. The second characteristic that the second consideration that people have pointed to is generally think of it as how long is the successful innovator going to be able to enjoy the prize? This often gets labeled as the appropriability principle. How appropriable is the innovation? And it's often assumed to be a question largely of just how strong are IP protections. That's not a that's not a generally true principle, because the dynamics of competition can be just as important, and recent research is kind of focused on this. The incentive, thinking about the intuition of the previous example, if having innovated and come up with a way to get an advantage over my four rivals, if those four rivals are just going to declare me the winner and walk away, then I'm going to get to enjoy that monopoly. If they're instead going to say, well, now we need to redouble our efforts and come up with our own version of this, or we're going to, in fact, invest even more in trying to leapfrog the innovation, then I may actually have much less appropriability of my prize, regardless of how strong the IP protections are. So that brings us to the third characteristic or consideration in these innovation markets that's been identified, and that's loosely speaking, how do the inputs combine to yield synergy? And this is really, at some level, the giant catch-all of the unknowability of the creative process. We've kind of thrown all the things that we don't know about what creates creation into this one category, and more or less the agencies tend to agree that there is some degree of synergy, in the sense that more inputs probably generate more output. It's kind of an assumption that someone who does understand the creative process is probably going to be able to find a way to use more assets effectively and actually achieve outcomes, or be more likely to achieve outcomes. And that's why you see the agencies almost never claiming that a merger is going to reduce innovations. You see them claiming that it's going to reduce investment in innovation, or it's going to reduce other inputs, or the enthusiasm with which competitors pursue innovation. On the flip side, the agencies tend to use this uncertainty when they're thinking about how those synergies play out in terms of efficiencies. They shift the burden of proof around and say, well, this is the great unknown. Can you prove that the combination of these assets is going to produce synergies? And of course, that proves to be just as difficult as you might expect from a category that's kind of the catch-all of all the things we don't know. So I think there is consensus among economists that these three considerations are a good way to describe the variety of economic theories out there. But how well do they do at actually, producing something that one could take and say, okay, now we have kind of an order of proof, or a list of factors we need to consider in every innovation market. And for that, I think it's very informative to look at how this was actually what the EC attempted to do in Dow DuPont. They went through essentially these three factors and tried to articulate a way that you could test whether each of them was held in a way that would suggest that a reduction in competition, or a structural change, was going to have a predictable, or at least a presumption of reducing innovation. I think it's telling that as the EC tried to implement this, they were left in a situation where they had to do something that, when you step back and look at it, seems a little odd, which is they had to measure shares of these competitors in order to get at a lot of the notions that we tend to employ around these generalized theories on the price side. In order to get shares, they used patent citations. And there's really, stepping out of the case, there's really nothing that makes you think that patent citations ought to be linked in any presumptive way to how innovative or how successful at innovating any particular company is going to be. Debbie mentioned that, measuring the amount of money people spend on R&D as a proxy for shares has similar difficulty interpreting as their effectiveness. I think patent citations are possibly even worse for this because a lot of companies have different strategic motivations for how many patents or how likely they are to patent any particular thing in the company. And nothing speaks to that better than the Coke secret formula, which of course is never patented, but was a critically important and still highly protected trade secret of the company. That's just a company philosophy. It's just a structural difference at the managerial level. It doesn't tell me anything about whether that company is more or less likely to innovate or be important to bringing some new innovation to market. So I think where that leaves us is that we're kind of left with the alternative, which is the way that these innovation markets have historically been evaluated, which is to just look at the facts of the case and the history and track record of this industry. Who is it that brings innovations to market? What makes them uniquely positioned, if it were, or makes a small set of people able to bring products to market or make the initial innovations? And how does that operate? So I could look at a market and say, well, in fact, the companies that are emerging aren't really the ones that do the innovation. The real creative part is done by venture capital firms that are taking all the risks and doing the innovation. What I've really got is 3 or 4 firms who specialize in competing for those innovations, picking the ones they want to champion and trying to bring them the rest of the way through a development process. That kind of rivalry, it actually fits a lot better with a typical kind of competitive model because it's not really rooted in what is it that makes them able to make that initial innovation. On the flip side, I might have an industry where I can look at it and say all of the creative innovations have been done by companies who have these particular assets or who have had previous successes in certain areas. And if that fact pattern suggests that this is the critical asset and lends itself to the other elements of a case, then I might be able to build a story that's unique to these facts of this case, not to a generalized theory of innovation markets, but actually does lend itself to a prediction of some degree of believability. Having said that, I think innovation, the one part I haven't really stressed is that we're predicting a future that often takes place, or the relevant parts of it take place very far out into the future compared to our typical, within a short period of time after a merger, is price going to go up or not? The complications of predicting the future multiply exponentially the farther out in time we try to look. And there has to be some degree of modesty in our ability to look forward and say, I know what it's going to be like this far down the road, and I know how well I can do that. The farther you have to look down the road, the less close you are to something more like it's already in the pipeline, it's ready to go kinds of things, the more you need to be aware that your ability to make those kind of predictions probably is limited, even if your models were perfect.
Thanks very much, Bob. So I think that's that you've seen in spades recently, just in Sabre FEINSTEIN, where you have just 2 days ago the judge saying, yes, of course you were a disruptor, FEINSTEIN, but that seems to have been 3-4 years ago, and that time period is an age in a dynamic industry. Currently, you don't seem to be very innovative, and in fact, you might have complementary skill sets that would improve innovation. Improve innovation in future. James, just moving from the theory around innovation mergers to the very nitty-gritty and practical. When you're looking at a forward-looking theory around innovation, as Bob says, it's inherently quite speculative. So what are the nuts and bolts of the evidence you put together to create your theory around the potential for innovation harms?
Sure. I guess at the outset, I think Debbie mentioned how the facts in any analysis of a forward-looking analysis of a proposed or in some cases consummated merger, the facts really matter. And I think Bob highlighted the need in many cases for being modest and recognizing the limitations that can be present when you're attempting to predict what the future is, particularly if you're talking about events that might not unfold until many years in the future. So I'll highlight a bunch of different kind of types of evidence that the FTC and the agencies in the United States look at. And just at the outset and at a high level, I think that the cases we're talking about here, the matters, this isn't a sort of, in the case of the FTC or DOJ, this isn't a list of the greatest hits. A number of these cases, complaints did issue on, and in that sense, the government won the day. But in probably about half of them, it didn't go that way. Either a trier of fact in the case of, for instance, the Sabre Fairlogics or the Stera Synergy case that Debbie alluded to earlier. Government brought a case and lost at trial. Roche Spark, Genzyme, both of those after long investigations, the commission closed. So I just wanted to highlight at the outset that I think the agencies do their level best to be modest and to recognize that these are very hard issues to analyze. And that for that reason, that's why you see a real variety of outcomes here when you look at the actual cases. Now, moving towards the, so what's the actual evidence that the agencies look at and find particularly probative? I'll start with what I think is really the most obvious one that is the case in any analysis of a proposed merger and its potential impact. First and perhaps foremost, we start by looking at the parties' own documents to ascertain what their view is of the products that potentially or we're alleging are going to compete in the future. And when we look at parties' internal documents, we want to know a range of things. On the acquiring firm side, we're looking across the company, but particularly at a high level sort of decision maker at the C-suite or at the board level. What do these high level company executives think? What are they forecasting based on their careful analysis and based on their allocation of R&D funds and the personnel to do the R&D? What are their views about either their own product or about the target's product that's could be in development? So what are we looking at? We're looking at emails. We're looking at meeting presentations to see what's being said. Do these decision makers over a period of time consistently view the acquiring target either as a competitor now or one that likely will be in the future? And if not now, when does the acquiring firm see competition coming to the fore? In addition, you'd look for is the target is the acquiring firm concerned about the acquisition target negatively impacting its business? Is it specifically concerned about losing sales? How long has it held that concern? Are there particular metrics or milestones that have been identified that can be used as a useful guide? The flip side is you switch over and you look at the acquisition targets documents. You look at their internal information, their board presentations, and see what the target expects in terms of taking business in the future from the acquiring firm. Is the target planning to compete for new customers or expanding its market into the future? In short, do the target's own business documents corroborate what you're also seeing in an acquiring firm's documents? So hot documents, of course, in any case are important and are exciting and fun to work with. But that's not the only type of evidence we look at. We're also looking outside of the parties' business documents to statements that the parties are making to third parties or to consumers in the marketplace. For instance, presentations to investors. What are the parties saying about their products and about the likelihood of future competition that will be beneficial to consumers? What are they marketing on their websites and the material that they send out to potential customers? We also gather information from third parties themselves, particularly customers. We talk to as many as we can to find out about their current and anticipated use of the products at issue. Do they expect the parties to compete in the future? What's the basis for that? Finally, I think the third or the last third party we will gather information from that can be relevant are competitors. What do their ordinary course documents say about the anticipated or expected competition between the merging farms? Competitor advocacy can be helpful and probative, but obviously we're mindful that competitors may have their own agenda. So it's really most useful, I think, when competitor views or documents line up and are consistent with the other sources of information that you might look at. Kind of the last category would be industry analysts. I think that's probably the least probative, often because an industry analyst is going to have little insight to the sort of depths of a company's R&D pipeline and portfolio, but it too can be sort of a corroborating, consistent factor you look at. Now, there are also other types of kind of more inchoate evidence that you'd look at when you're on the kind of far end of the spectrum and you're looking more broadly at the sort of second type of merger that the guidelines, the second type of innovation theory, that the guidelines identify, where you're concerned about, two firms that have the relatively unique capability and are a very small number of firms with that capability. You can innovate in a specific direction. The kinds of evidence you might look at there are the examples of past innovation leadership. In Bayer Monsanto, for instance, the parties in that merger, DOJ, determined, had long been two of a very small number of firms that were capable of bringing to market all manner of crop sciences and crop protection related innovations. Last thing I'll note is that, as Bob highlighted, on the economic front, there's a diversity of opinion and sort of no clear-cut modeling or consensus on how to analyze innovation issues like the ones we're talking about from an economic perspective. So I would agree with that, but I also think an important source of evidence and information that the agencies consider for cases that are far enough down the line that a challenge is possible is going to be what our internal economic experts, our colleagues at DE, what their analysis says. And when you often, as everyone is aware, you'll have hired an expert economist, and you'll want to know what he or she is thinking and how they see the evidence lining up. The Sabre Fairlogics case, for instance, obviously hot off the presses, but the judge at least noted in that case that some of the economic testimony by the government's economic expert he found unreliable. He thought it didn't reflect the commercial realities of the industry. So that, in some cases, can also, and in many cases, can often be an important source of evidence that is evaluated as well.
That's super helpful, James, to get a readout of the kind of nuts and bolts of how you might create a case. Particularly tricky, one might think, when it's a capabilities-only case, and therefore you're trying not looking at things that appear in the pipeline documents necessarily. But Debbie, it all strikes me as being super speculative. If you're looking at documents which, by definition, are a past view, not a future-looking view, and then we're trying to crystal ball gaze 3-5 years ahead, is that really something that you can do in a useful and administrable way? I mean, certainly we see the agencies doing it, but isn't that particularly dangerous with a standard civil burden of proof to show something is more likely than not to have a harm to competition?
So I think you raise a really good question, and there are really two issues. One is how far off into the future you can look, and then second, likelihood. And I think they're different but related. The first is how far into the future we should look. I think you could have situations where you are fairly certain about something, even if it's a year, 2 years, 3 years away, such as, generic entry. That generic entry is highly likely to occur, and you can sort of predict that it will come a fair amount into the future. You might feel more comfortable bringing that kind of a case. Looking years into the future, it just makes those predictions hard. But I'd say sometimes looking not very much into the future. It'd be interesting to see, basically, each day we're hearing that a new company is trying to develop a vaccine for COVID. And some of them are saying that they might be able to do this in 12 to 18 months. So one would think that's not a very far time span to be looking at. But we're such an early stage that the question of knowing at any time which one of them is the first, whether or not there are going to be, 3 of them or 6 of them, what would happen if 2 of them came to merge, and making predictions about what is going to happen, I think is really hard. I think it depends on, the type of product you're talking about, how far into the development process you're talking about, how many competitors there are. All of those things go into the mix. I use the example, and I get tweaked by this by a colleague who brought the case, but I use the example of the gene therapy cases. There was a merger many, many years ago of 2 companies that were involved in gene therapy. And the issue was whether or not the combination was going to help or whether or not it was going to reduce innovation, and the commission required a divestiture. Well, it was years and years and years and years before there was any successful gene therapy. And the question was always, well, did that merger actually help or not? One will never know whether or not, if you had had people in a room together, it would have been better. I think that's why those are so difficult to figure out. And the further off you are into the future that you're trying to make the predictions, and the earlier you are in the trajectory of the development. I mean, we know that products in phase 3 have a pretty high chance of success. We know that products that haven't even been tested in humans, that was the case in Genzyme Novozyme, the product had never made it out of a mouse. It's a lot harder to predict whether that product is ever going to come to market. So I think you have to look at not just the time, but where something is in the development process. Then in terms of likelihood, I think the case law is pretty clear on this, and the government's positions have been pretty clear on this. In a Section 7 case, you have to show probable. Now, what standard of evidence is required to be probable, people may disagree about, but I think there's probably general consensus that for a Section 7 case, it's got to be more than 50%. It's got to be likely, it's got to be probable. Now, that may not be the case for the specific example, as James mentioned, of a Section 2 case like QuestCore, where you have a monopolist, and the commission has at least taken the position that you don't necessarily need to show likelihood, that you're eliminating the threat of competition in that situation, that you ought to worry about it more than you might if it was reducing the number of competitors from 5 to 4 or 4 to 3. Maybe you shouldn't have to show that it's likely. You just have to show that it was a reasonable threat. That's certainly what the commission staff said in a blog post on the Questcor case. But I do think, and I think James is, there's certainly caution taken because, it is hard to, as Yogi Berra said, it's really hard to make predictions, especially about the future. And I think some regulatory humility is appropriate in those sorts of cases. Doesn't mean that you don't look at them, but it means that you have to think really hard about whether or not there's likely to be a concern and whether or not the facts of the situation suggest that there's likely to be a problem, as opposed to just, boy, there could be. And also, we're not going to balance the efficiencies in that case because, boy, efficiencies are hard to come by. I think in an innovation market situation, you have to think harder about what the but-for world might have looked like if it was a combination.
And I think that's a great point, isn't it? You're in a cleft stick. There's possibly an innovation problem. It's back to you to prove the efficiencies of showing all these synergies would be great and pro-innovative. You're not really able to do that, or the agency is not sufficiently happy with it. So we're now into the remedy zone. James, perhaps that's one for you. You've got a problem with an innovation deal. Prohibition might well be the remedy here. We've certainly seen those in the past. What other types of remedies might satisfy the agencies where there's an innovation problem?
Yeah, I think there are a range of remedies that may satisfy either the FTC or the DOJ in the case of a transaction where you've identified an innovation, likely innovation harm. I think it depends really on the kind of case you're looking at in the first instance. For any divestiture that's being contemplated as a remedy or other type of remedial action, we're always in an innovation case or other types of cases. The agencies always look to are guided by the principle that the remedy needs to replicate as best you can the competition that is expected to be lost as a result of the transaction. In cases like pharmaceutical ones, for instance, which Debbie has discussed, where you're talking about identifiable specific products, you can see for pipeline products with a fairly high degree of precision where they are in the development, in the phases of development, how far advanced, what kind of work has been done, what kind of work is remaining to be done. Cases like that are particularly well suited to structural divestitures, where the agencies will identify all the assets that pertain to a particular product and require that they be divested. So that'll be the production capability if it's internal. That can be easier if you're talking about a third party that's engaged in it, as well as any related assets. There's sort of two potential options there that you'll be faced with in a case like that, where you're looking at two identified products. You can have there's invariably at least one pipeline product. In cases like that, what the agencies often will try to do, but I would not say that this is a ironclad rule. If possible, the pipeline, the on-market product is one that generally may be a more favorable candidate for divestiture because it exists. You know it's on the market. There aren't additional development hurdles that need to be overcome. With that said, in some cases there could be complexities with divesting marketed product. If the tech transfer, for instance, if it's going to be incredibly onerous to transfer the manufacturing from one party to another, you could imagine a scenario where a pipeline product that looks to have a very high likelihood of coming to market, and that, say, is being manufactured by a third-party contract manufacturer. There, you're just divesting a contract and related intellectual property, API supply, that kind of thing. You can imagine a scenario under the right set of facts where a pipeline product might even be preferable to non-market product. But as a general matter, on-market products are products that are going to be something we would favor, all things equal, to divest. Now, as you move kind of through the spectrum of cases, and you get away from cases like a branded or generic pharma case where you have identifiable assets and related IP and know-how that can go with it, as you move towards trying to remedy a merger where you're concerned about a diminishment of innovation in a specific direction or therapeutic area, the types of remedies that can be in play there might move more towards R&D capabilities more generally. The Bayer Monsanto, which was mentioned earlier, would be an example of that, where you had a divestiture of the entire R&D capability, as well as related businesses that are going to be necessary to succeed, going into the future with ongoing R&D efforts. So there, you need to be careful and tailor that kind of divestiture carefully, so you don't under divest, and then also that you don't over divest, of course, and damage the acquiring firm or whichever party's assets are being divested. There are other remedies more equitably in the Quest Corp case, which Debbie knows very well and was involved in as bureau director. In addition to divestiture, there was disgorgement in that case to the tune of $100 million that Mallinckrodt agreed to disgorge the ill-gotten gains in that matter. The other types of issues you might look at when you're kind of on the field or innovation capability generally could be patent licenses, something along those lines that would enable another party to step into the shoes of the acquired firm or the acquiring firm. I think the farther down the line you get with those kinds of divestitures, I think you need to be careful and modest, as we discussed, and I think you'd need to carefully consider what it is, what the scope of any sort of remedy along those lines to determine that it's actually likely to be successful and that you can project that with some confidence.
Absolutely. You can see that a patent license might not get you all the way there if actually you want the clever mind behind the patent as well.
Exactly.
I think, so Jay, perhaps Debbie, Bob, maybe some concluding remarks from you as we're at the end of our time slot. Where next for innovation? Perhaps Debbie, you first.
Well, I think that it's unclear, and I think the agencies are all innovating on how to think about innovating theory, and I think we need to be a little cautious about it. I do think that it's important to be very clear about what the theory is and to be very clear about what we do and don't know about innovation. I do worry a lot about theories that basically say, for instance, anytime you eliminate some R&D expenditures as a result of a merger, that is by definition a diminution in innovation simply because you have decided to either spend less money. Well, maybe that's because you're being more efficient. or maybe because a given CEO has a different view of the likelihood of success of a program, which has nothing to do with the fact that you're actually, whether or not you're competing and whether or not it's an innovation harm, or simply I've decided that I don't want to spend my money innovating on product X, and the proof of it is I didn't innovate product X myself. To me, that's getting far afield of what competition law is supposed to be about, which is reducing competition as opposed to just reducing the amount of money spent on innovation. So I think I would say that I would urge caution, but I think that practitioners should be very alert to the fact that the innovation theories have taken a very broad brush on some of these issues.
Quite agree. So Bob, we just need a sufficiently innovative economist to thread the needle here and come up with the proper theory for us. What's your prediction there?
Well, I'm not sure you're going to find that, but I will tell you that the thing that has me most worried in this space is that we've kind of become fashionable to combine the worries about things like acquisition of a nascent competitor and the risk of killing that competitor, innovator, with another, an older school source of worry outside the scope of what could be directly proven, which is kind of the network effects in some markets and the propensity for markets to tip. And that's something that, when I was first starting out, I thought, that was a reason for great excess worry. With the benefit of hindsight, I can see that a lot of the things that regulators identified as products that were always going to be around with a monopoly, the network effects of Microsoft's operating system or the AOL instant messenger walled garden. Those turned out not to be so tipped to one product that they really did justify kind of this rationalized paranoia. And I think when we're doubling up on the rationalized paranoia to get to policy predictions or policy that gets us away from what really can be known or knowable in the facts of a case, it really does start to worry me that we're being too creative, too innovative about our theories. And so from that perspective, I would say that we need to be looking for people who can say, look, if the policy is going to be driven by something that, the papers maybe say, there's a 5% chance that even in the worst case that some innovative competitor is going to be killed off by an acquisition. If we're going to apply that, we ought to be applying it on both sides of the policy and thinking about, well, is there at least a 5% chance that combining two sets of resources to engage in innovation is likely to enhance the likelihood of a creative outcome? Usually we don't give that kind of chance much weight in evaluating efficiencies. To me, if we're going to go down that path, we ought to be balanced and consistent in how we think about our creativity, our theories of innovation.
Thank you so much. Well, thanks to everyone on the panel today. And John, there you have it. Apparently we are rational, paranoid, and too creative when it comes to innovation theories of harm.
Thanks, Bill. Lauren, let's take it back to you. What should we take away from today's panel?
Oh, well, I think there are really three main takeaways for me, at least. The first one is the difficulty of analyzing these innovation mergers. And again, I think this really comes back to having to predict even farther into the future than we ordinarily need to. And the second thing, I think, is that it is also quite difficult to analyze these types of mergers because the dynamics are changing. So particularly if you should have an extended merger review that can take up to a year, maybe even longer, you may have a different market in the beginning, toward the end. And also, if these cases go to be litigated, that is even more of an issue. That the way the market dynamics looked in the beginning might be quite different. A year, 2 years, 3 years down the line. And the last point that I think is quite interesting, and particularly with related to pharmaceuticals, is that very often it's not just money. These types of mergers often aren't something where giving more money, whether it's to potentially have a product divested or get a product to market in pharmaceuticals, does not necessarily resolve the problem. It's also a matter of making sure that there is the right expertise in getting that pharmaceutical product to market, and really understanding and how to bring that to people. So I think that this is very important, both in evaluating the merger and also in any remedies that the antitrust agencies are looking to impose.
Well, it sounds like it's a moving target. So I guess watch this space, and we'll keep everybody up to date. Relatedly, you're the co-chair of the Healthcare and Pharmaceuticals Committee. Can you tell us what the committee is up to and how young lawyers can get involved if they're interested?
Yes, that would be great. So we have kind of two sides in what we do. One is our programming. We have programs throughout the year. We have number one, we have our recent developments programming, both domestic recent developments that comes out 4 times a year, and we have our programming on international recent developments that comes out 2 times a year. And then throughout the whole year, we put on programming that pertain to healthcare and pharmaceutical issues related to antitrust. In terms of the spring meeting that's going on now, we are hopeful to bring 2 additional programs to it, one relating to rising drug prices, and looking at whether antitrust can help that situation. And the second is related to PBMs, which are pharmacy benefit managers, and looking at those as well. So those are 2 programs that we're hoping to get out soon.
And you're going to do this?
Our public.
I'm sorry, you're going to do the programs as committee programs, as brown bags?
Well, we're thinking of getting those 2. They'll either be brown bags, or we were thinking that they would also potentially be part of the rollout of post-spring meeting.
Excellent.
We also have, I'm also going to plug our 2 podcasts that have come out also on the rising drug prices. That we have one that I actually did with my old law professor, Professor Harry First, addressing the U.S. side, and then my vice chair, Bill Batchelor, did another podcast relating to drug prices and antitrust, looking at it from across the pond. You can check those podcasts out at our Curious Amalgam. They are number 25 and 35. And then in terms of our publications, we have our newsletter. We have weekly updates on what is going on via email through Connect, and we should hopefully within the next year be putting out our healthcare handbook. And I think for young lawyers, we are always thrilled to have young lawyers help and assist in any way possible, whether that is assisting on a program and helping us bring a program out to the members, or writing an article for the Chronicle, helping with our week in review, or working on the handbook. So there's definitely lots of opportunities.
Lauren, thank you. Healthcare Committee is doing great stuff. And thank you for all your good and the work of all of your co-leaders on that. I'd like to thank Lauren for coming in today and giving us her expertise. I'd also like to thank Bill Batchelor, who is the moderator of the panel, and all the panelists who put in so much work to get ready. And most importantly, I'd like to thank our members, those who are listening. Thank you for giving our virtual spring meeting program a chance. Thanks for joining us. And please, until next time, be safe and be well.
Thank you for listening to this 2020 Virtual Spring Meeting edition of Our Curious Amalgam. It is produced and shared around the globe by the American Bar Association Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the ABA Antitrust Law Section, visit us at ambar.org/antitrust to learn more. If you have feedback for the podcast or are interested in participating in a future episode, please reach out at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.